Thank you, my Lord. If I then may start.
Certainly.
By way of introduction, my Lord, this is indeed, in South Africa, a first case of its kind to be decided on this specific set of facts. And I base that on the fact that for all of the research that has been done, and more specifically the latest article by Dr. Beatrice Creer that I have referred the court to, and also attached as an authority, a comprehensive study was done of all of the cases that has been dealt with in South Africa, and this is the first one of its kind. And I say that because usually in a tip case, and I will refer to trafficking in persons further as a tip case, usually in a tip case, the main source of information and your most important
Can I just check something? Mr. Paulus, will you be able to follow the English argument? Oh, the interpreter is there. But if you, she's going to just give you a summary in Afrikaans, but do you understand English? Good. Mr. Van Rijn, understand? Smith? Just so that we don't miss anything. And I'm not going to have the argument translated into Afrikaans out loud. And we're going to deal similarly with the judgment. Good. Yes, thank you.
Thank you, my Lord. I was saying that usually in a tip case, the most important witness and most important source of information usually is your victim. In this case, we don't have a victim because our victim, little Jocelyn, is still missing. That in itself does not make that unique.
We have a victim, but the victim's voice is not heard in
Indeed.
Open court.
Indeed, my Lord. The victim can also not explain exactly what happened to her, as usually we do have. In this instance, my Lord, in all of the other previous cases, and I've referred the court to those cases, not to say that they are authorities and binding to the court, not at all. The purpose of actually referring the court to those cases, the Loubser and the Kutse matter, that's in the High Court in Pretoria, and then also the Zama Madladla matter from KZN. My Lord, in those cases, all of them, where the child was sold, it was actually a trap or undercover operation in terms of Section 252A. So in other words, the harm was stopped, and actually the child was never handed over, or if handed over, immediately then seized. So there was a police agent involved. In this instance, we don't have the victim, and that is why it is seen as a first on that basis. So my argument is, and no pressure, my Lord, but this is a very important case also for jurisprudence for South Africa. When we look at the crime of trafficking in persons, it indeed is a very heinous crime. My Lord, it is often referred to as modern-day slavery, and that is in essence what it is. It is the commodification of a human being, commodification of a person, for the purpose of exploitation. My Lord, in this instance, we are saying that our victim was sold, and that is our case, and that was a planned agreement between the accused. So, my Lord, contrary to normal belief, one would not want to say that one can value or put a value to a person or a person's life. When we're dealing with a hit murder, then the murderer is paid to commit the crime of murder. But in trafficking in persons, we're actually placing a value on the person itself. And that is why it is seen as such a terrible crime. A person is never supposed to be a commodity. And for that reason, there is no offense in common law or in statutory law that prescribes that the selling of a person is a crime. So that was a lacuna. And that is exactly why the legislature then, and in following the international obligations, more specifically the Palermo Protocol, the legislature then enacted this specific piece of legislation so that we can deal with that. For the reasonable person on the street, it would sound bizarre to think that a person can be sold, more specifically that a child can be sold. But unfortunately, we see in the cases that it happens, and therefore there was a need for this legislation. My Lord, if I then go to legal concepts in my heads of argument, more specifically to the offence of trafficking in persons, which the definition in South Africa is found in Section 4.1 of the Pakotip Act. Then we look at the elements of the offence. Now, my Lord, it is so that all international standards and following the Palermo Protocol, as I have referred to earlier, my Lord, our legislation follows that, and it's accepted that for trafficking in persons, we have 3 elements. The first element being the conduct or the act. In other words, what exactly was done. The second one being the means, how it was done. And the third one being the purpose of exploitation. My Lord, it's important to remember that in South Africa, or in our legislation, if you look at section 4.1, it doesn't specifically say that the elements itself is only applicable to a child or an adult victim if you only look at section 4. But you need to look at section 11 as well. So I deal with section 11 in point 2.1.2 of my heads of argument. And if one reads section 11, then it is my understanding, and this has successfully been argued, my Lord, that when we're dealing with a child victim, then there are only the 2 elements. Section 11 precludes the means as an element. My Lord, and I respectfully referred the court to 2 cases in this regard. The Ngasana matter, my Lord, that was Becky Ngasana and 2 others. Although it's an unreported decision, my Lord, it was a case that I prosecuted in front of Judge JOSHLIN, who's now a judge in the Supreme Court of Appeals. And my Lord, he deals with all of the concepts, international obligations, and also the understanding. And I specifically, my Lord, refer the court to...
Yes. It's
on page 51.
It's a transcribed judgment, so it doesn't have paragraph numbers.
Yes, my Lord. But that is the signed judgment.
No, that's fine. It's
on
unreported.
page 51, yes, it's unreported, my Lord, unfortunately. But it's also a very important case, and specifically because the judge actually deals with all of these concepts and also looked at the common law and customary law and all of that. That had to do with forced marriage case, of course, and sexual exploitation. But the principles are still the same. Now, in this specific case...
You're taking me to page
51.
Is that the portion where he says now the section?
That's correct.
Because he quotes section 11
yes.
up ahead.
Yes. Indeed, my Lord.
So that's at line 10 of the judgment. I'm there. I've got it open in front of me.
Thank you, my Lord. So in that specific case, I argued this, specifically as I'm setting it out now, that section 11 actually says it's not necessary, and the court agreed with my submission in that matter. And this is what he then says on page 51 thereof, when he then finds that when we are dealing with a child victim, it is not necessary to prove the element of means. Although, my Lord, I at the same breath also would like to say that I would almost want to say 99% of the cases, we in any event prove means when we're dealing with a tip case. But as a requirement, it is not necessary. We only have the act and then the intended purpose.
Well, it's interesting that in the Ngasana case, the judge refers to an article.
Yes.
Not the one that you refer to,
no,
because your one came later.
Yes, my Lord.
But that's the one by Creston.
Yes.
In the journal, and weaves into that argument the UN protocol.
Yes.
As well as reference to the Children's Act.
Yes, indeed, my Lord.
In coming to that conclusion. That's how I understood it.
No, my Lord, indeed. I referred the court then to all of those articles, and all of them were submitted, and it's clear that the Honourable Judge applied his mind and properly dealt with all of those authorities.
Because what I have here was a transcript of what was read in court. So it's not the written judgment.
Yes.
So that portion of the discussion one would normally not find in the text of the judgment.
No.
There would have been a footnote.
Yes.
And he says, by way of footnote.
Yes.
So the reference is that...
in his written judgment, it would be in a footnote.
And more often than not, lawyers don't read the footnotes nor go and check what those sources say. And that's where you get these arguments by counsel in court referring you to issues that are irrelevant or not appropriate.
Indeed, my Lord.
And in references are wrong.
Indeed,
because
my Lord.
People don't look at the cases.
We are all human, my Lord.
No, you would have realized the other day, I didn't take Ms. Nkabai on about Botswana.
No.
But I mentioned it was a judgment of Himstra.
Yes.
Now we know Himstra never sat in Botswana.
No.
I did it on purpose because I knew it was a Botswana case.
Yes, my lord, indeed.
Hence my reference to Himstra. And my reference to Lubaka is because in the judgment, not in a footnote, in the judgment itself, Nugent AJA, as he then was, refers to the Judge Akwo and says, Erasmus N, acting judge as he then was, referring to the 1999 trial.
Yes. Indeed, my lord.
So, yeah, I mention it because this is a typical way of understanding where the judge clearly explains that context.
Indeed, my lord.
I don't have heads from the defense on the elements of the offences charged. I don't know whether they might take a different view.
Indeed, my lord. My lord, that is why I am referring, my lord, to this specific matter of Nasana. Similarly, my lord, it was also found by Regional Court Magistrate Montgomery in the matter of Martini, and another. That was also a matter that I prosecuted. So I have the...
Yeah, but the Regional Court Magistrate had no choice because they were bound by the judgment of Goesenjay as it then was.
No, my lord, no. Nasana came after Martini. Martini was first, and then came Nasana. So that is, for that reason, I'm not suggesting...
But it's a very persuasive, even though I'm not bound,
yes,
it's a persuasive argument.
Thank you, my
as
lord.
made out. And coupled to that, it seems that we, the outlier, if it's a requirement,
Yes,
because in international law,
it's not
a requirement when it relates to a child.
Indeed, my lord, indeed. And our legislation, our Pakatip legislation, to a great extent corresponds with the definition as in Palermo Protocol, our Section 4.1. It's just a little bit wider than in Article 3 of the Palermo Protocol. But
even if the purpose would be a requirement, is that just not an infringement, Mr. Raw? Do you have to prove it positively? Or is it an inference the court can draw?
The means, my lord, or the purpose?
That the exploitative purpose.
Yeah, no, the exploitative purpose, my lord, I was just dealing first now, not just with the means. So my submission in this regard is, although we are dealing with a child and we do not need to prove the means in this instance, my submission is that we actually do have the means. And the means is in the form of the exploitation of the vulnerability of our victim. And as defined, my lord, one can actually see the abuse of vulnerability is any abuse that leads a person to believe that he or she has no reasonable alternative but to submit to the exploitation. And that includes, but is not limited, so it's not an exhaustive list, but it includes taking advantage of the vulnerabilities of a person. And that vulnerabilities may result from, and in this case, my submission is, what is relevant is that we are dealing with a child. One can also consider the social background or circumstances and the economic circumstances, as I set out in page 4 of my heads of argument.
Well, I don't know how far you've taken the timeline and the plan. I'm just opening it up because I haven't seen this before this morning.
My lord, when we deal with that...
So it seems to me that is it Ms. Herman that drafted this?
My lord, it was a team effort between Ms. Viraman and Captain Lombard, and then an insight from my side.
So I'm interrupting you because we're dealing with the means, the purpose. You say to me, we have to look at the social background, you have to look at vulnerabilities, you have to look at the relationship between the alleged perpetrator and the victim, and so forth. So when I was looking at it last night, I was wondering and asking myself, where do you start? Where do you start with your timeline?
The state is absolutely correct. This case, the JOSHLIN Smith case, is literally the first of its kind in South Africa. You know, usually there is a victim. Either there is a body or the victim has been retrieved. But in this case, the state has not located JOSHLIN. They do not know if she is alive. They do not know what has happened to her. They do not know where she went. There are a lot more I do not knows than knows. However, the state has taken the stance of somebody has to pay for the disappearance and trafficking of JOSHLIN Smith, and they've kind of drawn a line in the sand to say it is trafficking. It's not like JOSHLIN was kidnapped or anything. No, it is trafficking. And the state says that in this case, we don't have a victim. That in itself is a first. And when they say they don't have a victim, what they mean is, and this is my Lord saying, oh, you do have a victim. You certainly have a victim. What you don't have is the ability of the victim to use her voice in open court. That really hit so hard because this is something that has been said over and over again in the comment section, myself included. But where's JOSHLIN? Where is JOSHLIN? Someone said in the comment section yesterday, I hope while they're going through the case that there's still others who are still investigating the case and still out searching for JOSHLIN Smith. We know Gaten McKenzie says JOSHLIN is very much alive. She's very much alive. And this is just a bigger syndicate than we can ever understand or imagine. So in this clip, it's kind of an intro. The state is setting the stage of just how much of a heinous crime this is. Trafficking is the equivalent to modern day slavery, because it's still weird for me to say the price that they set on her. Do you have a conversation to say, no, they should have charged more, that was too low, how did they get to the 20,000 rands? They turned JOSHLIN into a commodity, okay, for the purpose of exploitation. So the state is saying that the victim was definitely sold. But then my question becomes, where is the money? Did the state find them in possession of the money? Now, the state also argues that one cannot put a value on a person. 100% here at Mzansi Unfiltered, we definitely stand with that. And a person is never supposed to become a commodity. Never, ever, 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 ever. So, now, the state moves their argument into, they're going to talk about what exactly was done, how was it done, the purpose, and the social economic circumstances. So we know that these guys were heavy substance users. So in the next portion, we're going to talk about Kelly the child. Because my Lord argues that where does the timeline start? Where does the problem start? It starts way before Kelly says, you know what, I think it's a bright idea that I sell JOSHLIN. Even that sentence coming out of my mouth sounds like I need to wash my mouth with soap. Sounds so taboo. So in the next video, we're going to talk about Kelly, where the timeline actually starts, where things went wrong. Let's go ahead and hit that like button. I'll catch you on my next upload. You know the house rules. I'm not going to do that because we've got a lot of uploads to get through. Bye.